So let's see what was said 2 weeks ago. This is July 30th. That feels like forever ago.
I don't
Can I
know
interrupt
if
you for just a second
Sure.
too? And I'm sorry, and I do want to hear, but is there anything else that Judge Glanville said that you believe is legally incorrect information?
Yes.
Okay, because I want you to address that.
We
as
need you
well.
to testify. Why do we need you to testify? That Mr. Copeland had to stay in custody till all 26 criminally accused have their case disposed of? That's not true.
Okay,
That's wrong.
Yeah. That is on, that's on page 36 of the transcript, lines 3 through, the discussion's kind of lines 3 through 9.
At some point, civil contempt becomes punitive. Civil contempt is supposed to make the person do the act. If the person's not doing the act at some point, it's just not effective. So it has to be then given a date certain. You can't just hold a human being in custody until all 26 people, some of them don't have lawyers, forever.
Yeah.
That's what Judge Glanville said. That's the problem. So I'm just being transparent. We're going to have a situation where Mr. Copeland's testifying. At some point, I'm going to be able to ask questions. I'm going to ask him, was there a time on June 10th, 2015, that you found yourself in an office with a judge? Was this person who I'm pointing at there? He'll say, I believe no. But the transcript says, exactly, you spoke with Ms. Love earlier.
If we get to that, that may be something that you are able to examine him about. And I do think that, you have the transcript, and I know everybody has said, oh, there was Brady in there. Y'all got it all now, so it's not Brady anymore. If it even was before, y'all have it. You can use it at trial. I think you can appropriately examine Mr. Copeland if he decides to testify.
If he decides to testify?
Some, maybe all of the things that happen in there, that may be something we have to hash out a little bit more. But let's not get ahead of ourselves. So with regard to legally incorrect information that the judge gave to Mr. Copeland, the two, page 40, 41, 24, 25, and then the one that I cited that you mentioned about all of, you may have to stay in jail till all of the co-defendants' trials on page 36. Anything else?
We need you to testify. Nobody needs him to testify. He could do whatever, it's America. He can do whatever he wants. He could sit in a jail.
Okay.
He has to pay penalty of perjury, but that's what judge.
All
And they also tell him how to testify. Judge Glanville tells the lawyer first. If you remember, I could get you the transcript. You remember you shaking your head. Judge Glanville tells the lawyer.
Yeah, if you've got a transcript cite, I think the more clear we are, the better.
Okay. It's at the beginning when Ms. Love was there. Okay, so I start with page 8.
Page 8, Mr. Copeland's not there. Mr. Copeland doesn't arrive until page 23.
Right, and you asked where the former judge was asking questions that I'd like to
No,
know.
where he gave legally incorrect information to Mr. Copeland,
Okay,
which is what you put in your motion.
well, okay, and page 8, though, if you take in consideration, starting on line 9, the former accused Judge Glanville is telling the lawyer for Mr. Copeland. Now, to be fair, I think Ms. Bunkus, as an advocate or anybody, has got to tell him, meaning her client, he's going to face some pretty significant cross-examination. And then Ms. Bunkus says yes, or excuse me.
Was that legally incorrect? I would think, given this defense team that's been accumulated, that's probably accurate, even though it wasn't said to Mr. Copeland.
The judge, though, and the motion is, calling the judge and the prosecutors and disqualifying prosecutors. The judge has stepped out of his role as a judge. What judge tells a lawyer, tell your client, whatever the words are, you make decisions, obviously, but this is how I read it. Tell your client he's going to face significant cross-examination. And you know what else? The judge goes further. The judge starts telling him that the client, he's telling Mr. Copeland that the client's are guilty.
Mr. Copeland's not here at this point in time. This is his attorney, Ms. Bumpus.
All right, let me get that for you. It's when the judge is saying, they, meaning the accused, know more about your criminal conduct.
Okay.
But let me find that. Okay, on page 26, Your Honor. Line 16. Mr. Copeland should be there.
Yes.
I'm just following what the court told me, 23.
Yep.
The court said, so if you, I believe Mr. Copeland, are worried about what the defendants may ask you because they may know your business, but if they ask you about things that you might think you might have some liability with, you can't be prosecuted for any of those. Why?
Well, I think because this whole thing has to do with the fact that there was a 507 immunity order granted,
But he can be prosecuted for this case.
which is not what the judge is saying there. Okay.
I don't know. I don't know any judge who gives advice like this. Then on page,
Well, if you are, I mean, if the topic of the meeting is to ensure that Mr. Copeland understands what it means that he just got immunity, which he certainly does not seem to at the outset of this meeting, and the nuances of that. I mean, that's a nuanced issue even for lawyers. It might be appropriate in the context of ensuring the client understands what could get him in jail for contempt and what the grant of immunity means, that he would explain to the witness, the potential witness, here's what it means. So, all right, I don't find anything improper about that particular one.
okay. On page 30, it's not the judge now, it's Mr. Copeland speaking. Page 5, I believe he's speaking about the district attorney, but in front of the judge. You told me before you went to the judge with whatever thing you went to him with, and I believe that that's the use immunity order.
Right.
You told me I can't, when I'm asked a question, I can say I don't recall or I don't remember, excuse me, I don't know. You told me that if I plead the fifth, I mean something. Why would I plead the fifth to something I ain't do? And I said that you don't know what I did and what I ain't do, and then you was like something. So to me, telling a person you can say you don't know, nobody should tell a witness you don't know. That's all the state wanted. I don't recall, so they could get in a prior. It's in front of the judge. And then with Mr. Talking about what the judge did or didn't do for cross-examination of Ms. Hilton and Ms.
Okay.
Love, that was Brady, as you said, evidence. Yes, I have it now. But why wasn't I told that? And I want to ask questions.
Okay, so Judge Glanville is off the case. That all would go to whether it's appropriate for Judge Glanville to be on this case.
My understanding of the law is the motivation for any witness to testify is admissible evidence.
Right, and you can certainly ask Mr. Copeland about that.
And I'd like to ask the judge on page 36, line 3, until the trial is over, until all defendants have been, I got these 6 that we have right now, then there's another 6. Ms. Hilton said, no, there's another 12. The court said, there's another 12 or thereabouts that are still outstanding for various forms or another, and they're talking about he has to stay in jail. And I'd like to ask Ms. Hilton, Ms. Love said the same thing, and Judge Glanville, why would you tell him that when that is not the law? You can't just hold a human being.
All right, so you can certainly ask Mr. Copeland about that.
Okay.
I don't know that the prosecution's motivations are relevant to the issues that the jury is supposed to decide.
All right. Yeah, so she said it twice, you guys. They can cross. The defense should be able to cross on this. Like, this is crazy. Call them liars out. And then there we go. So let's go back and watch earlier today.
Also, that reminds me that with regard to cross-examination, I know, Mr. Steele, you had at one point suggested an interest in cross-examining Mr. Copeland as to everything that went on during the ex parte. And some of that is no longer relevant. So anything, I mean, if you want to cross about things that the state said to him or that he said to the state, that's fine. But we have, I think, both circumvented and the whole coercion issue, and he has now been properly and correctly advised by this court and had the advice and counsel of 3 different attorneys that I
Hold
know
on. Look
of.
at the way this lady looked when she
So
said that. Does anyone know her
that
name?
should no longer 3 different advised
Look-
now
Look at this lady here. And I need to learn her name because I don't want to call her this lady. But look at the way she looks when Whitaker says a thing about the immunity being explained properly, finally.
been properly and correctly advised by this court and had the advice and counsel of 3 different attorneys that I know of. So that should no longer be an issue. And so that should no longer be relevant. So I would not permit examination or testimony about that. All right.
Well, of course it's okay because you are the honorable court. But I will make an attorney proffer
Okay.
because if you'll accept it, I could do it with Mr. Copeland, but I respectfully disagree.
Okay.
Mr. Copeland on the 7th of June, 2024 stated and in my the way I understand the law, he doesn't have a Fifth Amendment, but he refused to testify. And
Correct.
He used the Fifth Amendment as whatever, his statement. He made it clear to me as a reader of the June 10th, 2024 ex parte meeting that he was not going to testify. He said in court, outside the presence of the jury, that he was pressured. Please check the record with Ms. Winfrey. If he didn't use that word, he would use a similar word. He would never have testified except for that ex parte meeting where Judge Glanville pressured him, as well as Ms. Hilton. So I believe that it does go to his state of mind while he started to testify. Your Honorable Court, correctly, in my understanding of law, told him what is his options and how long he's looking in custody, and told him, I believe, the decision's his. The legal decision, though, will trigger you to have to exercise your discretion and hold him in contempt. So I believe that the jury gets to determine that information. In addition to that, Judge Glanville was with us since January 4th of 2023. This jury is all selected from the very first panel. To me, he was biased in front of the jury. I understand what you said, that, no statement, I appreciate what you said. No statement made by the former court disparaging of lawyers should be considered, or whatever the words were. But there's also going to be a jury instruction that nothing that the court says is intimated an opinion. And I disagree in this case with that instruction. I'm going to object to that instruction. And I need the jurors to understand that Judge Glanville, I will make it clear. I will make it clear. I will make it clear I am excluding this honorable court. But Judge Glanville pressured him. And I will argue to the jury that Judge Glanville was biased. And that is admissible because it all happened in front of the jury. And from just Judge Glanville's demeanor, and I'm not here to hurt Judge Glanville. In fact, I like Judge Glanville. But I don't know what happened in this case, but I like him before this case. But the way he conducted himself to people in this courtroom, I've never really seen a judge do. So I want to ask Mr. Copeland, it is very important to me to explain that he was taken against his desire into Judge Glanville's chambers, that he was with Judge Glanville, Ms. Hilton, his lawyer. I'll make it all perfect. If I don't, you could admonish me and the state can correct me, but I'm not here to snowball anybody. But to say that I can exclude statements of Judge Glanville and, most importantly, the conscious or subconsciousness of this witness, because I believe, and I've not spoken with him, Your Honor. I've not spoken with his lawyer about it. But I believe that Mr. Copeland will truthfully say that he believed that Judge Glanville and the state of Georgia are one. And that comes out when Judge Glanville specifically says, and I don't remember the transcript page right now, but it's something to the effect of, we need your testimony. There's no we. Nobody needs anybody's testimony. If he didn't want to testify, I've had witnesses tell me, I'm not testifying. We subpoena them and come to court. They're held in contempt. There's nothing that the judge can do because the judge can't give immunity, so they can't compel the person to do it. So the person invokes the Fifth Amendment and they just leave. That is unfortunate, but that's a reality. There is no we. So with all that being said, I'm making an attorney proffer that if you prevent me from doing that, and Judge Glanville prevented me already, I'm just telling you, he prevented me from cross-examining Agent Racy. He's an FBI agent on misstatements made by the prosecution, knowing misstatements, knowing the prosecution, it was Ms. Hilton, knew that a gentleman who's the same last name as a court reporter entered an invalid coerced guilty plea. Judge Glanville stopped me again from getting into the truth of that matter. It's never been corrected. The point I'm trying to make to you is that all came out in front of the jury. So yes, I am going to intend I will follow your rule, obviously, but I intend to cross-examine Mr. Copeland, not only what was said by Ms. Hilton, but what was said by Judge Glanville. I will be respectful. I'm not here to, throw some odd names about Judge Glanville. I will just be very specific. And then if he doesn't answer my questions, I'm stuck with his answer of, I don't recall, or whatever has been going on in this courtroom. But I don't believe that you should limit the cross-examination. I didn't do that. All that to me, that was very hurtful to me. And I don't mean hurtful. I mean, it was offensive to our law. That's how I took that. And I know what you said about it. I know what Judge Krause said about it. I look at it totally differently. I've never had a judge do that. I've done a lot of appeals. I know you've done a lot. I've never read a judge doing that. I've never seen a prosecutor do that. So I think that the jurors are entitled to know, and I think Mr. Williams because he's the one who, God forbid, gets sentenced if I lose. I think they are entitled to know what caused Mr. Copeland from the 7th to be locked up. The jurors saw that. They saw that. He was testifying. He answered maybe 3 questions, maybe 5. He said, I'm not testifying. He invoked his 5th. The jurors were sent out, and he was gone. Jurors come out, and they're dismissed. He's just not there. We're on a long delay. I think that it is not irrelevant to this matter. I think it is more than relevant. I think it's probative. And this is the actual treatment by the former court and the current district attorneys of this case.
Okay, I understand your argument, and I am not making my ruling in any sort of an effort to protect Judge Glanville. I do not believe it is relevant to the issues for this jury to determine. With regard to whether Mr. Copeland's testimony between the 7th and the 10th was, I'm sorry, between the 10th and the 12th, was impacted by the ex parte on the 10th. I asked everybody, do we want to do the entirety of Mr. Copeland's testimony over? And everybody said, no, we want what got testified to between the 7th and the 12th at 3 p.m. So y'all had the opportunity to have it all done over, and you chose not to do that. You can ask him about the immunity and whether he'd be testifying without being ordered to. That's fine. But beyond that, the ins and outs of what happened in the ex parte with regard to whether there was a biased judge or not are, in this court's legal opinion, not relevant to these issues. And honestly, even the we need your testimony, Judge Glanville had made a determination that Mr. Copeland's testimony and compelling that testimony by an immunity grant was in the public's interest. And so the we there is Judge Glanville, or can very easily be understood to be Judge Glanville saying we the public, and not we, me, and the state. So I appreciate your proffer, but my ruling stands.
Can I just add to that then?
Sure.
So it's in the eyes, the mind, and the ears of Mr. Copeland, not a reader who can say, well, that's the public. In addition, Judge Glanville said to Mr. Copeland, on cross-examination, you are going to get tremendous cross-examination. And they know you better than we do. So they know what you did. The they, I would ask Mr. Copeland, is referring to Mr. Williams, Mr. Ryan, Mr. Nichols, Mr. Stillwell, Mr. Kendrick, and Mr. Huey. And that presumes guilt, because Mr. Williams does not know the reality that Mr. Copeland has done all this other things, like pull a gun on Mr. Watts that he admitted today, shot into a barbershop that he admitted to on the stand. These are outrageous conducts. For Judge Glanville to make that statement, yes, the jurors should hear about it and the effect of Mr. Copeland. And you are respectfully taking away the opportunity that we are all given. Judge Glanville did this to a witness that's currently testifying. And if you don't realize this, because this is, I know your first witness. This is a big witness. He has been spoken about the entire case. I opened on him. I said that Mr. Copeland killed Donovan Thomas. To remove this, I believe, is going to be under the analysis of, it has to be harmless beyond a reasonable doubt, because it's a constitutional violation. So I'd ask you to listen to the remainder of the June 10th, 2015 statement, because he's going to talk about, he already has, and if you can't understand it, but the transcript seems to be, in my opinion, fairly accurate, where he talks about Mr. Williams. And if he didn't testify, none of this comes in. I think the jury gets to know that and why he testified. And it was because Judge Glanville held hands with Ms. Unlove and Ms. Hilton, and they coerced this man to testify, pressured this man to testify, whatever his word would be. So I ask you to just, I understand your ruling. I'm going to follow your ruling. I hope I made a good attorney proffer on cross, but those are the topics I would go in. I would not go into, and he also was, by the way, I have, based on information belief, he wasn't fed and did not drink from Friday when he was held in custody until Monday when he's in that star chamber. So I think that goes to his frame of mind as well. So, and when I say he, I'm talking about Mr. Copeland. And he was put into a jail in DeKalb County where the system was down, at least that's what he was told. He couldn't contact a family member. So I think that all that adding up to make his determination that, yes, I think that it's judge and the DA were going to hold me for not only this trial, but who knows how long 26 people can dispose of their case.
All right. Well, that part we definitely dealt with. If he was not given.
Okay, we're going to watch this little clip. We're going to watch this little clip. So this is going to be Woody talking about the contempt with DJU TV. It's a long interview. It's an hour and 30 minutes. So I just linked that in the chat. But this is where he starts talking about.
I call my people like, hey, look, y'all put money on the phone and money on my book. They listen to my call. I know they listen. They see that I'm getting comfortable. They remove me from that jail and put me in the DeKalb County.
So at first they put him with general population. And as soon as he's starting to get access to maybe something that he could use to buy some food and water, what do they do?
Jail and put me in the whole dorm by myself with no water, no TV, no phone, no nothing. No books to read, no nothing. So I'm like, dang. The next day, hey, can I get a pen number to use the phone? Or the system down. But y'all still putting people in. Everybody using the phone but me. Can y'all put the TV on or the TV don't work? If feces in the toilet, I gotta walk around like this the whole 24 hours. Can I get something to clean this up? I gotta clean the whole dorm just to get the smell out.
And remember, he's there for contempt. He's not there because he was convicted of something or for something that warrants punishment.
The toilet ain't working. It's full of waste. I was come feel bad for me. Fill it up with bleach. I bleached this thing down so bad that bleach was stuck in my nose. 5 hours later, back stink again. Flies, can't eat the food. I didn't eat Friday, Saturday, Sunday. Monday morning, they came for me. They were looking for me. They couldn't find me. So when they finally found me, I had came out the room. They like, where you been? We've been looking for you. I said, I've been in the only place y'all put me in here. I'm weak. I haven't ate. I haven't drank anything. No nothing. They're like, well, you got court. What I'm going to court for? I didn't know I had to go back to court. So they took me back to the court. And that's when they did all this bullshit stuff that I can't talk about right now. And then I'm explaining to the judge, the DA, I'm weak. I haven't eaten since Friday. I haven't drank anything. This jail is torturing me. I haven't talked to my family, no nothing. They're like, okay. So one of the officers, he felt bad.
So he's going to go on to talk about how one of the officers gives him apple juice and tries to give him some snacks, but he hasn't eaten in so long that, you know, sometimes when it's been a while, you feel a little queasy because you haven't eaten. And even though you should be eating something, you got to like sip your way back into it. So he ends up like sipping on some apple juice before he ends up later wanting to eat anything. That's how he was held. And I didn't get the impression that he was lying about this in this interview.
He gave me like some food, but it was like, you know, the food that they feed the deputies. And he gave me a lot of apple juices so I could get my energy back. But I couldn't eat the food. I just drank the apple juice. So he saw I was drinking, he kept giving me apple juice. This is the only person that had sympathy for me was the officer. So and I'm telling it to the judge, man, I'm weak. I need to go to the hospital, man. That man's going 3 days without eating anything or drinking anything. I can't even stand up and y'all gonna force me back in here. So I want to talk about so much so bad. I mean, because I know they're gonna try to shut me up. They're gonna probably try to put fake charges on me soon.
Can I speak? Am I covered federally? Because this interview was before Monday and Tuesday of this week. So again, this is a full hour and 30 minutes. He talks about his life story and growing up. I'm gonna, when I get a second, I'll edit and put it in the description as well. Like obviously this is live, you guys are chatting with me, but anyone in replay crew, I'll add it to the description. I listened to the whole thing. I thought it was a good listen. It was a great interview. So shout out to DJU TV for letting Woody speak and like give us some insight on what's going on here. But yeah, you hear all that. And if we toggle back to what was going on today, where the defense is saying, you know, we believe he was coerced. He had no food and water. So when he comes in, when he's brought back in, and Woody just said he didn't know he had to go back to court back in June. He thought he was good doing the contempt and was just going to be stuck in that jail, in that cell. They bring him back. He has no food and water while he's sitting there in that ex parte meeting with standing counsel. It was pretty similar to that one, you guys put it in the chat, just like that interview that started at 3 a.m. And then, remember, that happened, it says 6 days ago on YouTube. It happened before Monday and Tuesday, and Judge Whitaker's denial reason was, you guys should have put that in your other motions. Well, they just became aware of it. Partially because you didn't really let them do much questioning on it. And you certainly didn't let them put Hilton on the stand. You certainly didn't let them put Glanville on the stand to ask them questions.
Or you have a reason to believe he was not given food or drink between Friday and Monday. That's something that certainly should have been raised in the coercion motions that several of you filed, because that might have impacted between the 10th and the 12th. But again, you all decided you wanted the testimony between the 10th and the 12th. And that was a strategic decision on your part because you believed that there were beneficial things that he said during that testimony. I think that advice that these defendants, through their attorneys, would vigorously cross-examine Mr. Copeland is correct and accurate advice, and that these defendants know him better than the state's attorneys know him or anybody else is not inaccurate as well. If you would like to, understanding the parameters of my ruling, provide some questions that you believe should appropriately be asked, I'm happy to consider those. And it may be that there are, I mean, you can absolutely, again, ask him about the immunity grant and even right now, whether he is only doing this because it's avoiding jail for him. That's fine. You could explore that completely. All right.
You say it to Mr. Shard all the time, and I always tell him, don't say okay, because it's like you're
Well,
waving it. So no, it's not.
By which I mean, all right, do you understand? Not all right, do you accept my ruling? Because I know you will abide by it, but you do not agree with the correctness of
Yes.
it.
And then the last thing I'd like to say, if I may.
Yeah.
When this honorable court said I didn't take up the opportunity to strike the entire testimony from the June 10th to the 12th, that's the law. The law is until that motion is filed of recusal. So I'm following the law, and there were beneficial points. I mean, just read the transcript where he testified under pressure or not, but that is in the case. So I believe that I have a right to ask him about, those days before you took over, before you gave him the proper admonitions and the correct law. So that's
Okay,
all.
thank you. So that the record is clear, I am suggesting that obviously the law with regard to the timing, once a recusal motion has been granted, what you have to undo. Yes. What I'm saying is if you believed that there was coercion starting at some point earlier than that, based on a lack of food and drink or any kind of treatment like that, then that could have been brought up. And y'all chose not to bring that up or not to make that.
And to be fair, Steele could have said that, this is 6 days ago. It was after we did these motions. But still, he said, upon information and belief, I now know. And then Doug Weinstein does come in later and say, look, we just found out about this. It's new. We couldn't have put it in these other motions. Maybe we'll get some new motions on it.
That argument. And you all could have agreed to redo the entirety of the testimony, or you could have asked to redo the entirety of the testimony on the basis of it having been coerced, and I would have considered that.
Well, at the time, I was following the court's order, which I didn't think I even needed an order, but that I could cross-examine Mr. Copeland on everything that happened on the ex parte meeting. And that's when I made my ruling, or not ruling, sorry. That's when I said, I don't want it out. In addition to that, I didn't want it out because I want to cross-examine him on why he did it. It's why he testified from the 10th to the 12th. That's part of the case. And I think that it goes to the jurors. The jurors are entitled to know who the prosecutors are and who the judge was. And it goes to their bias, their interest in the case, and their motivation on how they are prosecuting this case. So.
Okay, I don't think that any order that I issued led you to believe that you would be able to, well, it may have led you to believe, but I don't think it should have reasonably led you to believe that you would be able to explore anything about what Judge Glanville said or did during that ex parte.
I think that it was clear to me, whether you said or not, the way I understand the rules, that that's a part of this case, that's a part of this witness, and that it comes out on cross or direct examination. The prosecutors can sit here and say now, maybe they're going to do it. I have no reason to believe that they are or not. But Mr. Copeland, we had a misunderstanding on June 10th, and we had a meeting with the judge, and your lawyer was there the whole time. They could do all that as well. But I don't see handcuffing Mr. Williams' lawyer on cross-examination when it is a reality case. Just like Mr. Copeland went out and spoke on a jail call and made statements about things. That's his state of mind at the time. It may be relevant. I think it's relevant here. I think it's relevant that Judge Glanville did this and Ms. Hilton did this.
You can ask about anything Ms. Hilton did.
No, I understand you did not limit that, but you're limiting the way I heard you today. I have to almost excise Judge Glanville, and that's what I'm objecting.
All right. Yes, sir.
Just so I'm clear, with what the court just ruled, we can ask about things that Ms. Hilton said to Mr. Copeland during that ex parte meeting. We just can't label an ex parte. This is what I'm concerned with. There's a lot of confusion and I think misunderstanding of this immunity. I understand the order that was granting him use and derivative use immunity. However, Ms. Hilton articulated to Mr. Copeland in chambers much more than that. For instance, my understanding of law, and Your Honor, I know that you've dealt with these issues more than me, the statute of limitations is not what we normally think it to be. It's not from the date of the offense. It's told if there's no evidence of who committed the offense. Mm-hmm. That's one, the perpetrator has to be known. So Ms. Hilton said, for instance, we'll use the barbershop shooting. Ms. Hilton said, oh, all this stuff is older than 4 years, so you can never be prosecuted. that he could be prosecuted
Yeah,
for the
that's true.
barbershop shooting.
But here's the
They would just
thing,
have to put a tolling provision.
is that's not relevant either, because it is not the fact that the statute of limitations may or may not have run that prevents the state from prosecuting him for something he wants to get on the stand and confess to. It is the grant of immunity that prevents that. So regardless of the correctness or incorrectness of statute of limitations comments, they cannot use anything he gets on the stand and confesses to because they granted him immunity.
Now, we looked at that a bit yesterday, and from the verbiage, it seems like he cannot be compelled to provide testimony or produce other evidence that could be used by another court. So I still think this right here, what Whitaker is saying right here, is still also incorrect, or at least incomplete. It might be correct if we make the assumption that she's only speaking about this particular court, but she doesn't really state that explicitly.
Or the court has granted him immunity.
But in my mind, here's the difference. The state has made a deal with the, quote unquote, I'm not calling the man the devil, but that's the saying. And there's a difference between them saying, oh, we're giving you use and derivative use immunity versus them saying, we will absolutely not prosecute you. They have basically, I don't know if they checked with Rich Homie Kwan's father, but they basically given this man carte blanche to never be prosecuted for anything he says. And if I was representing Kenneth Copeland later on and they indicted him for something like this, I would say, y'all must be crazy. Y'all got in the back room and told this man, you guys are never prosecuting him. So they've done more than giving him use immunity. They've given him blanket immunity for everything. And that, to me, is fertile ground for impeachment and cross-examination. And I think the jury needs to know they want Jeffrey Williams, they want Shannon Stillwell, they want these people so bad that they gave Mr. Copeland just full reign to run around Atlanta, do all these things. And as long as you get up on the stand, we're never going to prosecute you. And I think that's relevant.
Okay, well, they didn't give him full reign to go do things he hasn't done yet. So, I mean, let's not
they
get
made him
too
think
far
he-
afield with this.
They made him think he had full reign. He might not have believed them. He might not have bought that, but they led him on to believe that he was good in the clear for anything. So let's not mince words, Ms. Whitaker.
So
You may explore any kind of interest he might have in testifying in a way that might be beneficial to the state, although I don't think that's happened anyway. Because you could explore bias. You're entitled to do that. But we're not getting, this is not a trial about how the state handled Mr. Copeland or how Judge Glanville handled Mr. Copeland. This is a trial about whether these defendants, whether the state can prove that these defendants committed the acts that they allege them to have committed. And if you want, again, you also, all of you all are welcome. If you want to give me a list of questions that, or that you believe should be able to be asked, I can look at them.
very well, Your
All
Honor.
right.
Go ahead, Mr.
I just want to raise something.
Sure.
While you hopefully reconsider. And this was mostly, the prosecutors. I think Mr. Atkins, I was going to exclude him, but I think he did it too. They asked witnesses, to my knowledge, without any basis, well, you're testifying
point.
this way, but have you ever had to testify before in front of Mr. Williams? When you were giving your statements, was Mr. Williams present? And then they did it with everybody. Was Mr. Huey present?
Right.
And I've objected every time. And it's totally, that's a crime of witness intimidation without any evidence. It's just, and they say, no, I haven't testified at all, but I don't remember, or I told you something wrong, or I didn't say that to you. I want to do now and show what the state is doing to witnesses. And I'm telling you, Your Honor, when Mr. Zachary comes, and I brought this up earlier in a pretrial meeting, my understanding is that Ms. Love had him served, he being Mr. Zachary, served with a subpoena.
Okay.
It's a trial subpoena from what I was told. Ricky Richardson was his lawyer at that time. Ms. Love ordered Mr. Zachary the day before to drive from Augusta, Georgia, miss his job, to her office because she said, if he doesn't come, Judge Glanville will lock him up. There was no trial going on. This in 2023, we were doing jury selection. I heard about that, so I raised it to Judge Glanville. This is abuse of power. You don't order somebody to come to your office with the hammer of the judge going to lock you up. Judge Glanville said, put on your evidence. He gave me an opportunity. Everybody said they didn't want to testify, so I didn't call anybody. Ricky Richards, I didn't call anybody, so I forfeited the motion. But my point is to say that, somehow there's witness intimidation from Mr. Williams et al. I want to show what's really going on, and that ex parte meeting helps illustrate it. I will also ask Mr. Zachary, because I'm confident he'll know. It was not attorney-client privilege because It didn't just come from Mr. Richardson. He told me, you can also speak with Mr. Zachary, with Mr. Richardson, and he'll tell you the same. That's all we spoke about, coming to court. And he did come to the courthouse. I'm told that his father met him there too. This could be wrong because I'm not there. And then his father said, the law, there's no trial going on. My son's leaving. So that's what, there was no conversation.
Okay.
But my point is, this is not an isolated incident, and I'd like you to just allow the truth to flow. I'm not going to hurt Judge Glambo. I'm just going to state what was said. That's it. And it's really the
Look at the closed caption. Not Judge Glambo.
impact, like you said, on Mr. Copeland.
All right, thank you. Sure. Do you want to wait and see what Mr. Weinstein has to say first?
Okay. Briefly, Your Honor. The discussion this morning came up about Mr. Copeland being deprived of food and water at Rice Street, as well as conditions, other issues that happened at Rice Street between June 7th and June 10th. And I believe the court said, I may have misunderstood you, that several attorneys filed motions regarding the coercion in the chambers. Perhaps this is something that we should have brought up. I was completely unaware that that happened.
Well, it's not, I'm sorry to interrupt, but I'm not sure it did happen. He has some reason he thinks it may have happened.
Okay.
He Mr. Steele,
So,
but okay.
So I did not learn of this.
Whitaker cannot relate to what people go through at all. Oh, I've never experienced that, so I'm going to doubt when someone tells me that that's what happened to somebody else, or that somebody would do something to somebody else. I'm going to doubt it because I've never experienced it, and that is so frustrating. Like, you're a judge that sat over plenty of cases with regular people. You can't just sit up there and make your rulings based on your personal experience.
Possibly happening then, let's put it that way, until I saw Mr. Copeland on social media this week. So this isn't something that I could have brought up regarding Judge Glanville and the coercion that took place. So if we do get further facts of that, I would like to bring that up with the court again, because it sounds like that could have influenced your decision on the coercion.
And you know how they can get further facts on that? You guys put it in the chat. How can they get further facts on if Woody wasn't given food or water and was held in certain conditions between June 7th and June 10th? How could they, what's one way, what's the best way that they could get the facts on that? There you go. Let them ask Woody on cross-examination about these things that the judge does not want them to be able to ask about. Exactly. This whole argument this morning is to limit the scope of cross-examination. You could just ask him. Just ask him. And yeah, you could look at the videos in jail. That's another literal way. But relating to this issue this morning, don't limit what they can ask him on cross. Let them ask what they should be able to ask on cross. Why is Judge Whitaker pushing so hard against the scope of what cross can be about? Like, it's just nuts. It's just nuts. There you go. There you go, Susan. They don't want it out.
Perhaps not, but I would like to bring it up in the future.
All right, thank you. Mr. Engelberger.
And thank you, you guys, the whole chat, for being willing on the lunch break to go back to watch the stuff from July 30th, pair it up, line it up against what was said today on, we are on August 16th. What Judge Whitaker said this morning did not match what she told the defense on July 30th. And those things that she said on July 30th were things that she used the defense used in their consideration while they decided, well, do we want to strike all of Woody's testimony? Are we okay with striking it on June 12th? So they made certain decisions based upon the expectation that Whitaker gave them back on July 30th, that they'd be able to ask certain questions within the scope of cross-examination. And this morning she tried to, in my opinion, severely limit what they could elicit through cross-examination questions from Woody. And Woody, again, he might try to say it himself. It seems like Brian Steele might try to wedge in some of these questions either way. And I think he's very skillful. I think he can find a way to ask certain questions where it may seem like he's only asking about Hilton, but expects that the witness, Copeland, might give an answer that explains what everybody in that room was doing. So therefore, it will be Woody that brings up Glanville, or Glambo, as the closed captions are saying, and he won't actually have to put that in his questions. So I do still think we'll find a way to get that questioning, but for the judge to limit it at all is just so insane. It turned my stomach this morning. It turned my stomach even more seeing it mismatch what she told us on July 30th. Just nuts. No, She Do It says, Woody said it on the stand Monday and was ignored. Yeah, he tried to speak. When he says something like, can I speak? He's about to say he doesn't like something that was going on that was done to him. And when he tries to talk about certain things, it gets steamrolled over, it gets ignored. We'll just have to see with Cross if that changes a little.